Hello, good afternoon. Thank you so much, everybody, for joining us today. My name is Corey Ranger. I'm a registered nurse. I use he, him pronouns, and I'm the president of the Harm Reduction Nurses Association. Today's webinar is jointly hosted by the Harm Reduction Nurses Association and the Doctors for Safer Drug Policy. And your co-moderators today are myself and Dr. Jess Wilder from Doctors for Safer Drug Policy. Today's webinar is titled Responding to Police and Health Service Settings, Know Your Rights, Protect Your Clients. Before getting started, I just want to acknowledge that the Harm Reduction Nurses Association does work with individuals and organizations across all of Turtle Island and honor the life force of Indigenous people who have had their land stolen and who continue to resist ongoing genocide. Addressing the root causes of the toxic drug supply is deeply connected to decolonization, and I myself today am joining from unceded Cowichan tribe territory in what is colonially referred to as Duncan. I also want to acknowledge that a lot of the information that the HRNA gets to share with folks is made possible by people with lived and living experience of criminalized drug use, sharing their knowledge and expertise with folks like myself, with folks like Jess, folks like Caitlin. And so we're just incredibly grateful for that knowledge and expertise. And we wouldn't have all of these vital life-saving harm reduction services were it not for people who use drugs, innovating and implementing services while larger institutions and organizations lagged behind in their response. For those of you who don't know, the Harm Reduction Nurses Association is a national network of nurses with a mission to advance harm reduction nursing through practice, education, research, and advocacy. You should really become a member. Like really, this is a great opportunity to be part of a growing national community of nurses committed to harm reduction. It's a great opportunity to influence the direction of practice, policy, research, and resources in the nursing field, and to access unique opportunities like this, position statements, collaborative work. Even recently, a group of nurses with the HRNA got to collaborate on the wound care for people who use drugs harm reduction best practice recommendations, which is now published through the nurses specializing in wound and ostomy care. Like I said, I'm not gonna spend too much time on this, but we need numbers, we need strength and solidarity. And so if you're a nurse and you're watching this and you like what the HRNA has to bring, please consider joining us. And lastly, if you've got money to spare, we have a scholarship. We support nurses who work in harm reduction to go back to school. This scholarship, the Chapman Family HRNA Award, is reliant on donors. And so if you're interested in supporting our cause, please feel free to scan that QR code and submit a donation. Now, the reason why we're all here today. I'm so grateful that Caitlin Shane is joining us. Caitlin is a long-term ally to HRNA. We've gotten to work with each other on a number of really important things. She is a staff lawyer at Pivot Legal Society, a human rights organization based in the downtown east side of Vancouver. As Pivot's drug policy lawyer, Caitlin takes direction from drug user-led movements. She has appeared at the Supreme Court of Canada, the Federal Court of Canada, and the BC Supreme Court. Prior to becoming a lawyer, Caitlin worked as an outreach and harm reduction worker in tent cities, safe injection sites, and low-income housing. Caitlin, thank you so much for being here. Over to you.
Thank you. Thanks, Corey. Thanks, Jess. And a huge thank you to Harm Reduction Nurses Association and Doctors for Safer Drug Policy for hosting me. Also, big thank you to everyone here who took time out of your busy schedules to tune in. When Corey said that there was 200 registrants, I was shocked that there's actually 200 people on this earth who want to talk about the law. So that's really great. Corey said this is a very topical issue, Caitlin. So I'm glad that we're here. The guide that I'm going to be talking about throughout today's session is really and truly inspired by folks like you. So this feels like a very good room to be in. If I could get the next slide, Corey's going to be controlling the slides, I believe. We have limited time today. The guide itself is something like 30 pages, and I can say with certainty that we're not going to get through all of its content, and that's okay. For the first 30 minutes or so, I'm going to walk us through some of what I consider to be the most important takeaways from the guide. So that's going to be things like speaking to police, search and seizure, cop watching, and restricting or mediating police entry to services. There is going to be time at the end for Q&A, and I understand we are going to be turning off the recording at that time. So you can feel free to ask all of your freakiest questions, and it's not going to be recorded. And you can also always email me too if you have follow-up questions, and I'm more than happy to chat. I'm also more than happy to discuss additional webinars or in-person workshops if you're feeling like you and your coworkers might benefit from some more sort of targeted information and advice. So yeah, my door is always open. I'm always here. Don't worry if you're not able to get your question answered today. We can chat in future. If I could get the next slide. So responding to police in health service settings is a guide that we at Pivot published last month. Again, it was inspired by folks like you. One of the best parts of my job is interacting with really dedicated, principled healthcare providers like yourselves, who are on the daily resisting police powers because you care about your clients. After BC's decriminalization policy ended, I personally received a huge influx of requests for information and advice and workshops from service providers who were really concerned about the presence of police in and around their services. And certainly just the sheer volume of requests that I got indicated to me that there was an increase of police interference following the end of BC's decriminalization policy. So those requests in turn led to me traveling around the province and doing workshops for groups, organizations, workplaces, crews of friends, to talk about what our rights are and what our clients' rights are when we're engaging with police. And one really clear thing that came out of those workshops was a desire for a concrete resource that really spells it out for people. So that's what this is. I do wish that the information in the guide was, universal for all healthcare providers, but different provinces can have different laws oftentimes, and different workers obviously have different workplace obligations and contracts. So primarily this resource is for BC-based service providers, but there is a bunch of information in it that is that would apply to service providers across so-called Canada. So you will see in the guide under different sections who this applies to and who it doesn't apply to. So it'll say if this only applies to BC folks, what kinds of services it applies to, and also distinctions between publicly and privately employed folks, and whether or not you have obligations under a professional college. The one thing I would say while engaging with this guide is to always check your workplace policies and your employment contracts and any guidance from your professional college before relying solely on the information in this report. Who your employer is and what your role is in relation to a professional college can determine certain ways of interacting with police, whether it's refusing their entry to your workplace or cooperating with requests for client information. The report is available to download online. We also have hard copies. Please just email me and we will ship them to you. We do offer these resources free of charge and we won't ever turn anyone away, but we do welcome small donations from organizations that can afford it so that we can continue to provide them free of charge to under-resourced groups and community. Okay, next slide. One thing I'll just quickly say is that all of the guidance I give around interacting with police is always going to be subject to personal safety and the safety of your clients. So you all know what feels safe and what doesn't. And I know plenty of folks for whom, actually ignoring or denying requests of police can literally be dangerous. So I'm not here to shame anyone who feels that to follow the guidance here would escalate police violence. You know that better than anyone. I will say that the information in this report is based on over a decade of experience engaging in police interactions, witnessing police interactions with clients. And so I stand by this information, but evidently police treat people differently depending on their race and class and drug use. So regardless of what you do decide, whether you decide to speak to police or not, I'll just say that it's better to stay silent than to lie. Lying to police is grounds for obstruction charges. You don't want to go there. So to the extent that you can, and we'll discuss when you can, rely on your right to stay silent. I'll also just say that sometimes our clients don't want us to escalate or engage with police. So also defer to your clients. I know it can be, you get the urge to step in and resist, but sometimes, folks will be quite clear that that's not helping right now, and they just want the interaction to be over and done with. So listen to your clients. Okay, we can move into sort of the nuts and bolts. Speaking with police. So this slide should actually just say no. Not really, but at most times, and we'll talk about the exceptions, you and your clients have a right to silence. And if there's one thing that I'd like for people to walk away with today, is that they do exercise the right to silence. Why? Because everything that you or your client says can and most likely will be used against you or your client at a future date. Even the most seemingly benign interactions are intentional fact and evidence collecting activities. If you think about an example where an officer approaches you and says, have you seen Charlie around here lately? And you say, oh, I haven't seen him today, but I saw him 2 days ago. Well, maybe Charlie has a no-go for that block, and you've just unknowingly incriminated him or contributed to future charges against him. So just always keep in mind that nothing you say is casual. It will be recorded. It will be used against you. So keep that in mind. Also, and as we'll get into shortly, you actually may be legally prohibited from sharing personal information about your client to police, depending on your role and privacy laws. I think people have a tendency to think there's going to be legal consequences if I don't give information to police that they're requesting. And actually, the inverse may very well be true, that you could be breaching your client's privacy and in turn privacy laws if you're giving information about them to police. So we'll talk about that shortly, but keep that in mind. So there's very few and limited circumstances in which you must speak to police. In those instances, the only thing you have to say is your name and address, nothing beyond that. And the instances in which you do need to provide your name and address are if you are arrested, if you are being detained by police or a bylaw officer for the purposes of issuing a ticket. So they need to know who to send the ticket to. They need your information for that. And if you're stopped by a police or bylaw officer while riding a bike or driving a car, emphasis on driving, not if you're a passenger. And I will explain kind of the differences between arrest and detention in the next slide. But just know that in those instances, the only thing that you need to provide is a name and address. There will never be an instance, subject to a few circumstances, in which you have to provide an officer with anything other than that. You're not going to have to tell them what you're up to, where you're going, who you're going with. It's limited to name and address. And if you are arrested and you ask to speak to a lawyer, I guarantee you that when your lawyer picks up the phone, they're going to tell you to stop talking and not say anything else. So exercise your right to silence at all times. Next slide. Generally, if you or a client is interacting with police, it's going to fall into one of three categories of interactions that I like to think of as falling on a bit of a spectrum. So, starting with the least restrictive type of interaction, we have a street stop. The most restrictive type of interaction is an arrest. And then somewhere in the middle is what we call a detention. So, a street stop is a situation in which a police officer stops you, usually on the street, to engage in some type of conversation, whether that's a, hey, how are you? Or what's your name? It's a seemingly informal type of interaction, and you have no legal obligation to answer their questions. And there's nothing preventing you from walking away. So police use street stops as a way to collect information. And they also rely on the fact that most people think that when an officer asks them a question, they have to answer it. So street stops are oftentimes also called like carding. You might have heard that term as well. So how do you know if this is just a street stop? And when it is a street stop, if you're allowed to walk away, which you are in a street stop, how do you determine that that's what this is? And what I always say to people is the simplest way to figure out what kind of situation you're in is to ask, am I free to go? If you are free to go, police are required to tell you that. And if you are free to go, you can, and I would recommend, subject to your own personal safety, I would recommend walking away at that point. The simple question of, am I free to go? I can't emphasize how helpful and important that can be. If police don't directly answer the question and continue to follow up with more questions, you can continue to ask, am I free to go? Am I free to go? They need to tell you, and if you are free to go, you can go. One of my proudest moments as a lawyer was watching someone from VANDU, the Vancouver Area Network of Drug Users, standing out front with a megaphone in front of a police officer's face and just saying, am I free to go? Am I free to go? It's, it was a chef's kiss moment where I was so proud. And it's something that, can be the difference between us getting stuck in an interaction that could be incriminating down the line. So that's a street stop. If you ask, am I free to go? And the answer is no, you're now in one of two possibilities. You're either being detained or you're under arrest. A detention is a situation that effectively means you're not free to walk away. You can't go away, but they don't have enough evidence yet to arrest you. So again, it's kind of this limbo stage between a street stop where you're not allowed to walk away, but you're also not under arrest. It's a situation in which police have what we call reasonable grounds to believe you're connected to a crime they're investigating. But again, they don't have enough evidence to arrest you. You're not free to go. And if you're getting a ticket, you do need to give your name and address. But again, that's the extent of the dialogue that needs to happen. Also, importantly, a detention doesn't necessarily mean you're going to be arrested. It's just kind of the preliminary stage that could lead to arrest, but it also could lead to you being free to go. An arrest is a different legal standard. It's when police have reasonable and probable grounds to believe that you have or you're about to commit a crime. You will be told when you're under arrest. If you're not told you're under arrest, you're going to want to document that. And we're going to talk extensively about the importance of documenting all police interactions. But once you're under arrest, you have a right to be told that you're under arrest and why you're under arrest. And here is where you would give your name and address, and you ask to speak to a lawyer, and your lawyer will tell you to say nothing else. Each of these stages obviously comes with different types of rights and restrictions. So if I could just go to the next slide. And mostly those rights and restrictions are, or at least in large part, related to search and seizure. I don't want to get too deep into the weeds of search and seizure because it's in the guide and because it can be somewhat finicky. But what I will say is that there's limits to when police can engage in a search of your person or your belongings. If you are detained, they can conduct a frisk or a pat-down search, and it's got to be for safety reasons only. For instance, looking for weapons, and they can seize those weapons. If you're being arrested, this is what we call a search incident to arrest. They have a few more powers when it comes to searching. So they can conduct a search of you, your clothes, your belongings for safety reasons or to discover or preserve evidence. Again, it's very hard in the moment when this is happening to kind of identify whether or not your rights are being breached in the course of a search or seizure. That's why immediately after, or if you're a witness during these interactions, it's super important to take notes of what's happening, because police have certain restrictions in terms of how and when they can conduct specific types of searches and seizures. And that information can be really helpful down the road if someone is before a court and there's evidence that police were acting outside the scope of their authority. Another instance where search and seizure is permitted is if police have a valid warrant. And the main thing I want to say about warrants, actually, if you could go to the next slide, Corey, is that warrants are not a sort of like a fishing expedition. It's not an opportunity to enter into any place at any time and look for whatever. Warrants are issued to police on very specific conditions and circumstances. And if police say that they have a warrant, you're going to want to look at that warrant and review it to make sure that they're actually acting in accordance with it. So there's a big section in the guide on what to look for in a warrant, but basically you want to look at things like the date and time. A lot of warrants are time and date specific. And if they're permitted to go in on the 13th, but it's the 14th, that warrant is no longer valid. Also, warrants are specific around location. So it will give an address and it may specify a room or even a desk drawer. Oftentimes, warrants will be very specific about the items being sought. If the item on a warrant says we're here to look for a stolen bike and they start going through cupboards and drawers, that's an invalid search under the warrant. Same thing if it's an arrest warrant, it's going to have an individual's actual name. So the main point here being that you want to search the warrant, you want to review the warrant and you want to make sure that it's being acted in accordance with. Okay, next slide. I can imagine I've probably reached the point of the presentation where people are wondering what happens when police don't follow these rules. What happens when they don't answer my question about whether I'm free to go, or they're telling me that I can't refuse their entry to my service, or they're acting way outside the scope of the warrant. It probably comes as no surprise to you all that there's often a really large distinction between what the law says on paper and how it plays out on the ground. So when I talk to people who use drugs or unhoused folks about their rights, I'm very often told that those rights, can mean very little in practice, unfortunately. And that's where the importance of documentation and archiving comes into play. And I would say, if the first golden rule is staying silent, the second or equal rule is document everything. Cop watching is a term that effectively means you're documenting, whether filming, recording, or note-taking, an interaction between a police officer or police and a person. And the sort of rationale behind cop watching is that if police know that they're being watched, they may be less likely to escalate an interaction or to become violent. I would be lying if I said it also can't have the opposite effect. But generally, I would say that cop watching is more likely to reduce potential harm. And it can also assist clients in future legal proceedings, or inform police complaints if you choose to go that route. Again, police oftentimes will flout the rules. And in those situations, I would say rather than try to interfere or obstruct, because again, that can be a criminal offense, when you do notice that police are persisting past your refusals or your objections, that's when you switch into cop watch mode. That's when you step back for your own safety and your client's safety, and you start documenting the situation in every detail possible. Cop watching is legal. I have heard that police will oftentimes say that you're not allowed to film them. That's absolutely not true. You just need to keep a reasonable distance and not physically interfere with the investigation. So obviously, if you've got your camera, don't get up right in between the officer and the person. Maintain a distance. You can tell them, I'm recording this. I'm just a legal observer. I like to make a practice of asking the person, I'm here, I'm filming, is that okay with you? You want their consent. Also, if you are, I believe certain colleges have guidance around filming clients, so it can only be done with consent. So you're going to want to have a look at those workplace policies. But yes, generally cop watching is legal so long as you keep a distance. And so long as you're not in a situation where there's an emergency and you're asked to leave, like if there's a live weapon and they're telling you you have to go, then you have to go. Next slide. A few common questions I get about cop watching. Do I need consent to film? You do not require consent to film police. It's a good idea, again, to ask for consent from the individual being arrested or detained. And I think it goes without saying, don't share or publicly post recordings without their consent. I like to make a practice of just announcing that I'm filming to signal to police that someone is paying attention here and they are being held to account, and also to give support and encouragement to someone who's probably going through a very traumatic experience. I'm filming this interaction. I'm here with you. I'm documenting what's happening. Giving them that support can make a difference for sure. Can police seize my phone? No, not without a warrant. You do not have to hand over your phone or send the police any files from it. So yes, absolutely, your phone is considered very personal property, and they're going to need a warrant if they need to access that. Again, what kind of information to track? You're going to want to track date, time, location, police ID. So the identification of a police officer is generally on their chest pocket area. They'll have their surname there and their badge number. License plate is also extremely helpful, as is the number on usually the left bumper at the back of the car. If you can't get their name or surname, if you get their license plate and the date and time, they can usually put the pieces together to identify who the officer is. Many police, in my experience, like to cover up their badge number and their surname. In fact, I don't think I've ever seen a surname out in the wild. It's always covered. At least in Vancouver, and I know in Victoria as well, if you ask for their badge and surname, they are legally obligated to give it to you. That's part of their policies. So most police departments have that policy. I believe RCMP does as well. So you should always ask for a name and badge number and write that down. You're also going to want to take down things like witness contact information, details about police actions, timing, when was the person's rights read, were their rights not read at all? Things like that can all be super, super helpful and also signal to police, again, that they're under scrutiny. Okay, next slide, please. So I mentioned earlier that there tends to be, I think, a very understandable assumption that if a police officer is asking for something from you, you have a legal obligation to provide it. And that's not the case. And what I want to make sure folks are aware of is that if you are a service provider, there are privacy laws that protect the personal information of people who access your services. And generally, those laws prevent disclosure to police of personal information unless they have a warrant. So the two kind of primary laws that we're talking about in BC are FIPA and PIPA, Freedom of Information and Personal Protection Act and Personal Information Protection Act, I believe. FIPA applies if you are a public service employee. PIPA applies if you are a private service employee. The law in both instances is quite similar, and both laws define personal information very broadly. And this is important because I think when we think of personal information being requested by police, we're thinking of things like medical charts, medical information, birth certificate, that kind of thing. And that obviously is personal information that you should not be disclosing unless circumstances allow it. But personal information includes things like names and addresses. So that could be not just text or email communications. It can be something as simple as a tenant list or a client list, sign-in sheets, stipend records, meeting minutes. All of that data includes personal information that you are actually legally prohibited in most cases from disclosing unless police have a warrant. Under both PIPA and FIPA, and this list here that I have it's not exhaustive. You'll want to go into the guide and look at it in more detail. And I've also popped in the QR codes of various different health authorities and employers for their own specific privacy policies. Those privacy policies, so like for instance, Vancouver Coastal Health's privacy policy, will have been drafted in accordance with standards of FIPA. And so, it's helpful to look at FIPA, but you're definitely going to want to look at your workplace policy because that will set out the specific examples and how they've interpreted that law. But generally, you can't disclose personal information to police except when legally required. And when you're legally required, that's if they're giving you a warrant or a production order. And certain exceptional situations for public employees, gunshot, stab wound, that kind of thing. And those particular instances where it's required by law will almost certainly be set out in the privacy policy of your employer. So I was looking at VCH's policy this morning, and there's a whole chart at the end that sets out when you're actually legally required under the law. You'll probably also, many of you will just know this because it's part of your day-to-day job. But yeah, there's very limited circumstances in which you must comply and disclose. The law also provides instances where you may disclose. So again, that's not saying you have to. You have every right to refuse unless legally required. But it's saying that the law generally is blanketly saying no disclosure to police except when legally required, or you can, if you choose, to assist in a police investigation or to avert a risk of significant harm to health or safety. That's oftentimes in relation to Mental Health Act apprehensions. And I hate to say it, but the Mental Health Act situation is evolving currently in time with changes around laws and the legislation itself and policies. So that's unfortunately still somewhat of a nebulous area, but warrants are almost always required. When in doubt, you can contact the Office of the Information and Privacy Commissioner, And oftentimes, public employers will have their own information privacy office. So that's another place that you can check. Okay, next slide. What I've been hearing most often from service providers is the concern about police entering their services and police telling them that they have a right to be there because it's a public space. It's true that police can enter into a public space like anyone else, but it's also true that you can lawfully refuse their entry. Once you do that, there's very limited instances in which they can override your refusal. Again, they either require a warrant or there has to be some other exceptional circumstance. Those circumstances, I won't get into them in too much detail. They are all outlined in the guide. It's usually warrant, hot pursuit, abandoned 911 call, that kind of thing. But I think the most important point here is that you as service providers have an opportunity to protect your clients' health and safety and access to healthcare through the development of policies that limit police entry. Over the last year, I've had a real pleasure of co-drafting several policies with healthcare providers who want to restrict police access to their services. And policies like these, even if police ultimately flout them, honestly, are a really critical signal to your clients that you stand with them and that you believe in their access to harm reduction as healthcare. We all want access to health services without stigma, without judgment, and with the knowledge that our care providers can be trusted. And this is just one way to do that. And I can assure you that if you do decide to do it, you won't be the only one. This is something that more and more service providers are considering and implementing. It's not controversial to tell police that they need legal grounds to enter. It's well within your rights to do that. And I'm more than happy to support or assist any person or group who's thinking about putting one of these policies in place. Okay, next slide. And we're just about at Q&A time. If you are considering adopting a policy to reduce police entry to your service, there's a few options. Again, these are detailed in the guide. The first very straightforward option is posting this notice in your space on the door or in the window. It is the centerfold of the guide, so you'll see it there. And I can also email you a copy if you need it. What it is it's a letter from the Public Safety and Solicitor General of BC to police from 2026, instructing them that since the end of decriminalization, enforcement of simple possession is not a priority in and around health services. And that includes harm reduction services, supervised consumption sites, overdose prevention sites. It's a recognition that these services save lives and they need to be accessed without fear of enforcement. I will be completely honest, the fact that PSSG actually issued this notice was shocking to me. It effectively acknowledges that police do in fact deter access to services and that this was a major problem after decriminalization ended. I have no doubt that the reason behind this notice is likely because service providers were showing up in opposition and saying this is not okay. So that I consider that to be quite a win for us all. That's a first option. Next slide is actually drafting a workplace policy with your colleagues or your employees to limit police entry to services. And the sample here is from a previous report that I did with the Vancouver Area Network of Drug Users called Talking Back to the City. And there's a whole policy in there, but there's also a policy in the guide. A policy like this just says that police will only be permitted to enter without consent when they have legal grounds to do so. So under the law, those circumstances are limited. They include things like having a warrant, again, abandoned 911 call, hot pursuit, certain exigent circumstances. Again, I won't go into all the specifics, but what I want to flag here is that the process of developing a policy like this together is an incredible opportunity to explore and critique power within your own organization. It's a process that allows workers to better understand their rights in the face of police in the best interest of your clients, and B, to examine our own varying power and privilege as workers. So I've had groups work together to identify who's going to be the one to turn away police at the door, who's going to be the one to do the cop watching. And making those decisions amongst yourself forces really important conversations about our own comfort and discomfort, privileges, vulnerabilities. So if you are considering developing a policy, consider doing it together as a team exercise, because it can be really valuable. And also, I'm more than happy to review any policy and provide any guidance and even work through it with you if that's what you want. So I think that is the end of it. Is there another slide, Corey? Thank you. That's it. Thank you. That's my email address. Please feel free to get in touch whenever you need.
Thank you so much, Caitlin. What a wonderful job. We're so appreciative that you're here. Before I turn off the recording and move into the Q&A, I will just tell folks that this recording will be available on the HRNA YouTube channel. You can find the document Caitlin is referring to on the Pivot Legal website. And yeah, here's her email in case you want to reach out and discuss more. And I will now turn off the recording. Thanks everyone for joining.
That's great. Okay.